The subpoena arrives on a Wednesday. Standard government envelope. Your name typed in the window. You open it the way you open everything official, standing at the counter, coffee in hand, reading once quickly and then again slowly. Witness summons. Superior Court. Case number. A date 3 weeks from today. A name at the top of the document that belongs to the case. The name of the case is the State versus Raymond Holt. You know Raymond Holt. You worked alongside Raymond Holt for 4 years at a financial firm in the city, whose name you no longer say in professional contexts because of what happened there. You know Raymond Holt the way you know anyone you spent 4 years in proximity to, his coffee order, his habit of clicking his pen during meetings, the specific way his voice changed register when he was managing something he did not want managed by anyone else. You read the charge. First-degree murder. You read the victim's name. You put the coffee down. You read it again. The victim's name is your name. Your full legal name, middle initial included, typed in the clean administrative font of a court document that has been filed and processed and that exists now in the official record of the state as a verified fact. The state believes you are dead. The state has charged Raymond Holt with killing you. The state has subpoenaed you to testify as a witness in the trial of your own murder. You stand at the counter for a long time. You look at your name in the victim line. You look at your name in the witness line. Both are you. Neither makes sense. You pick up your phone. You call the number at the bottom of the subpoena. You tell the clerk who answers that there has been a mistake. She asks for the case number. You give it. She confirms the case. She confirms the witness name. She asks if you are confirming attendance. You say you are the victim. She is quiet for 3 seconds. Then she asks you to hold. Chapter 1. What Raymond Holt Did. The prosecutor's name is Daniels, and he meets you in a conference room on the 14th floor of the district attorney's office on a Monday morning with a specific expression of a man who has been doing this job for 16 years and has not, until this week, encountered a situation for which his training provided no useful framework. He tells you the case from the beginning. You listen to it the way you listen to something that is about you but that you are hearing from the outside for the first time, with the disorienting quality of reading your own file. 14 months ago, Raymond Holt reported you missing to the police. This surprised you because you were not missing. You were in Portland. You had left the firm, left the city, left a professional situation that had become untenable in ways you chose not to formalize through HR channels or legal action, because the leaving itself felt like enough, and sometimes enough is what you can manage. You told 3 people you were going. You did not tell Raymond Holt. You had specific reasons for not telling Raymond Holt. Holt told the police you had been behaving erratically. That you had made statements suggesting you were frightened of someone. That you had mentioned his name in a context that he now, reporting this to the police, found significant in retrospect. The police investigated your disappearance with the thoroughness available to them, which was limited by the fact that adults are permitted to leave cities without notifying colleagues they dislike. They found nothing suggesting foul play. They found nothing suggesting you at all. Then Holt provided something. A storage unit registered in your name in the city you had left. Inside the unit, which the police opened with a warrant, were items consistent with your possession. And in the back of the unit, in a container that Holt had provided the police the specific tip to look for, were remains. Human remains. Remains that a forensic examination identified as consistent with your physical profile and that a DNA analysis, run against a sample Holt provided from your former office, your coffee cup from your last day, confirmed as yours. You look at Daniels. You ask him how a DNA analysis confirmed remains as yours when you are sitting across the table from him. He looks back at you with the expression of someone who has been asking this question for 4 days and whose answer is currently being processed by a forensic laboratory that was not expecting to reopen a closed identification. He says the sample Holt provided was not your coffee cup. Someone else's DNA was on that cup. Someone's DNA that matched the remains because the remains and the sample came from the same source. A source that was not you. A source that Holt acquired and planted and submitted through a chain of evidence that the investigation accepted because the investigation had no reason to question a grieving colleague providing a personal item from a missing person's workspace. Raymond Holt built your murder from the outside in. He found remains. He found a matching DNA source. He registered a storage unit in your name. He reported your disappearance with enough specific detail to direct the investigation toward the conclusion he had already constructed. And then he waited for the conclusion to arrive, which it did, and he was arrested for your murder 11 months after you drove to Portland and started a life that did not include him. Chapter 2: Why Raymond Holt Killed You. Daniels tells you why on the second meeting. He tells you because the why is the thing the defense will attack, and he needs to know what you know before the defense knows what you know. The financial firm. 4 years of proximity. The specific way Holt's voice changed register when he was managing something he did not want managed by anyone else. You managed something he did not want managed. Not deliberately. Not as an act of opposition or exposure. You noticed a pattern in a set of accounts you were asked to review, and you documented the pattern in a memo that you submitted through the standard internal channel, and then left in the system when you departed because leaving it felt more honest than taking it. The pattern was Holt's. 14 months of redirected client funds moving through a structure that was sophisticated enough to survive a casual review and not sophisticated enough to survive the kind of attention a detailed memo from a careful analyst would eventually generate. You did not know when you wrote the memo what it described precisely. You knew the numbers did not align. You documented the misalignment. You left. Holt found the memo 3 weeks after you left. You know this because Daniel shows you an email Holt sent to a personal account on the day he found it, an email that was recovered from a device the investigation seized, in which he describes the memo and its implications for him and what finding it means for the timeline he is now working against. The email is 4 sentences. The last sentence is, "She cannot be findable." You read that sentence twice. She cannot be findable. Past tense, future tense. The decision made in the writing of it with the specific flat clarity of someone who had already passed through the considering and arrived at the conclusion. You left a city to escape a professional situation, and the professional situation decided that leaving was not a sufficient distance and built a grave with your name attached to someone else's remains and waited for the law to close the file. The file closed. For 11 months you were officially dead in a city you had left and alive in Portland making coffee and taking walks along the waterfront and existing inside a life that the state did not know you were living because the state believed it had your DNA in a container in a storage unit and a murder charge filed against the man responsible. Chapter 3: The Courtroom. The trial begins on a Thursday. You sit in the witness waiting area with the other witnesses whose cases are being heard and who have the specific shared quality of people waiting for a thing they would prefer to not be waiting for. Nobody in this room knows what you are waiting for. The bailiff who checks your name against the list looks at it twice, and then at you, and then at the list again before he marks it confirmed. Daniels prepares you for 2 hours the morning of your testimony. He tells you what he will ask. He tells you what the defense will ask. He tells you that the defense attorney, a woman named Park who is very good at her job, will attempt to establish that you are not who you say you are, that the witness the prosecution has produced is not the victim the state identified, that the identification was wrong not because Holt constructed it, but because the forensic process failed and the person sitting in the witness chair is someone other than the person in the case file. You ask Daniels how you prove you are yourself. He says the same way anyone proves anything in a courtroom. With evidence, with consistency, and with the specific quality of testimony that juries recognize as true because it contains the texture of lived experience rather than the smoothness of constructed narrative. He says tell the truth exactly as you know it, and let the truth be complicated where it is complicated, and do not try to make it simpler than it is because simplification is what Park will look for and find and use. You walk into the courtroom. You sit in the witness chair. You look at the room. You look at the jury, 14 people who have been told they are hearing a murder trial and who are about to see the victim testify. You look at the defense table. You look at Raymond Holt. Holt looks at you with an expression you have seen once before. In the email. The flat specific clarity of someone who has passed through the considering and arrived somewhere. He arrived at she cannot be findable. He is looking at you being found, and the expression contains the specific quality of a calculation that has produced a result outside the model. You look back. You do not look away. You have been not findable for 11 months in a city where the waterfront is cold in the mornings and the coffee from the place on the corner is always the right temperature, and the life you built after leaving is quiet and entirely yours, and you are sitting in a witness chair in a courtroom in a city you left because a man who is looking at you right now decided your existence was a problem he needed to file under resolved. The prosecutor stands. He says your name. He asks you to state your relationship to the victim. You look at the jury. You look at Holt. You say your name again. You say I am the victim. The courtroom does the thing courtrooms do when something happens that falls outside the prepared categories of everyone in the room. It goes completely still. Chapter 4: What Park Does. Park is as good as Daniels said. She approaches the cross-examination with the specific composed energy of someone who has spent the weekend building an alternative architecture for the facts, and who believes the alternative architecture is sound. She establishes the forensic identification. She walks through the DNA analysis with a forensic expert she has retained who describes in careful technical language the process by which the original identification was made and the ways in which that process, correctly followed, produced a result that the process itself cannot be faulted for. The process was correct. The input was corrupted. Park does not say this. She presents the process as correct and allows the jury to sit with the correctness of the process and the person in the witness chair simultaneously and feel the friction between them. She asks you about Portland. She asks about the 3 people you told before you left. She asks why you did not notify your employer formally. She asks why you left no forwarding address with the post office, no change of address with your bank, no notification with any of the institutional infrastructure that people who leave cities in ordinary ways typically notify. She is building a picture of a person who disappeared deliberately and completely, and whose reappearance 14 months later requires an explanation that the defense does not have to provide, but that the prosecution does. You answer everything. You answer with the texture Daniels told you to bring. You tell them about the memo and the pattern in the accounts and the specific reason you did not formalize anything through HR channels because formalization requires remaining in the place you are formalizing about, and you needed to leave more than you needed the formalization. You tell them about Portland and the waterfront and the coffee from the corner and the specific ordinary quality of a life rebuilt in a place where nobody knew the name Raymond Holt. Park asks you one final question. She asks how you explain the DNA. You say you cannot explain the DNA because you did not provide the DNA and you did not register the storage unit and you did not place anything in the storage unit, and the explanation for the DNA is sitting at the defense table and has been sitting there since Thursday morning looking at you with the expression of a calculation that produced a result outside the model. The jury looks at Holt. Holt looks at you. The courtroom is still again in the specific way it was still when you said I am the victim, and the prepared categories of everyone in the room were asked to accommodate something they were not built for. Chapter 5. The verdict. The jury deliberates for 2 days. You stay in the city. You stay in a hotel 3 blocks from the courthouse, and you walk the waterfront in the mornings because the habit of waterfront mornings has become the thing your body reaches for when it needs the specific steadiness of something chosen rather than imposed. Daniels calls you on the 2nd afternoon. He says 2 words. You stand in your hotel room with the phone in your hand and you look out the window at a city you left 14 months ago, and you think about a storage unit and a coffee cup and a 4-sentence email and the last sentence of it. She cannot be findable. You were found. Not by the investigation that built a case around your absence. By a subpoena. By a clerk who asked if you were confirming attendance. By the specific administrative machinery of a legal system that sent a letter to your forwarding address, which you had given to exactly one institution because that institution required it, which was the court itself, for a jury summons from 6 months earlier that you had deferred and that the court had rescheduled and that arrived as a witness summons for your own murder because the court's address records and the case management system existed in the same database, and when the case was filed the system found your name in both places and sent the subpoena to the address it had. You were found because you had once, 6 months before you became officially dead, reported for jury duty. You think about this. The specific ordinary civic act of reporting for jury duty. The deferred summons, the rescheduling, the database, the subpoena, the envelope on the counter on a Wednesday morning with your name in the window, the coffee you put down when you read the victim line. Raymond Holt is convicted on a Friday morning. First-degree murder. The charge will not be modified to reflect that the victim is alive because the law does not have a clean category for this, and Daniels says the conviction stands regardless because the act of constructing the murder was the crime and the crime was committed regardless of whether the body was real. You find this both legally precise and philosophically interesting, and you tell Daniels this, and he looks at you with the expression of someone who is glad this is over. You take the train back to Portland on a Friday afternoon. You watch the city recede through the window. You think about your name in 2 places on the same document. Victim and witness. Dead and present. Filed and findable. You think about the waterfront and the coffee from the corner and the quiet specific life you built in a place where nobody knew the name Raymond Holt. Nobody knows it there anymore either. It is in the record now. In the database. In the system that found your address and sent a letter that started everything. It is filed under convicted. Under resolved. Under the category that asks no further questions. You arrive in Portland as the light is going. You walk from the station. The waterfront is cold the way it is always cold in the evenings, and the coffee place on the corner is still open, and you go in and you order and you sit by the window and you look at the water and you are here. Completely. Findably. Undeniably here. You drink your coffee. It is exactly the right temperature. You watch the water. You stay until the place closes. Then you walk home.